This is LXBN TV, and I'm Colin O'Keefe. A federal judge recently ruled that a company's takeover of its departing CEO's LinkedIn account was lawful under the Computer Fraud and Abuse Act. To explain the case, we bring in Martha Zackin, attorney with Mintz Levin and author on their blog, Employment Matters. Martha, first, can you give us some background on the case and the court's ruling?
Sure. What appears to have happened, I have no inside information. All I know is what I've read in the case documents that I've accessed. And what happened is the plaintiff, Linda Eagle, started a company along with a partner. It was acquired by another entity, and that didn't work out that well for Ms. Eagle, and she was terminated. During the course of her employment, she had established a LinkedIn account. She had given her password to an assistant to maintain the account for her. The company had a policy that she had established and she had implemented whereby employees were encouraged to establish LinkedIn accounts, were established to reference EdCom, her employer, in those accounts, that the company helped maintain those accounts, and they were clearly, by virtue of the company's policy and practice, used for their business. Historically, when somebody had left, the company would continue to mine that LinkedIn account for sales leads and other information. So there was a practice of the company, so to speak, taking over accounts subsequent to employees' departure from the company. She was fired. Her LinkedIn password was changed. And for a matter of, I think it was 2 or 3 weeks, she was not able to access her account. The company went in and not only changed the password, took down her picture and referenced her as the company's CEO and put up a picture and information about the interim CEO. They didn't change all of the information under that CEO's photograph, so there was still some reference to Ms. Eagle's awards and history, but it was clearly not her anymore in the picture or in the role.
This case was, of course, examined under the CFAA, which I think they ended up saying, potential lost business isn't, cognizable damage under the CFAA. So, is the CFAA really the only statute where she could have asked for support?
I believe that it is the only federal statute that would have potentially provided support. She filed a number of counts in her complaint. I think it was 11. 2 of them, or 3, because I think there were 2 CFAA ones, but there was also a Lanham Act, which is a Trademark Protection Act. My guess, and it's purely a guess from looking through everything, is that she wanted to be in federal court rather than state court, and in order to do so under the particular procedural requirements to be in federal court and the specific facts of her situation, she needed to plead federal causes of action. So she pleaded claims under the CFA and under the Lanham Act, and both of those were shot down a week or 2 ago by the court.
I see. And we have multiple things going on here. I think there was even a trade secrets claim, and one thing that I've seen before is that it's not a trade secret. People can see your LinkedIn contacts, so that doesn't apply. And then we have the CFAA. That doesn't really apply because that was really intended for hackers. So, it seems that the laws in this area seem in some ways woefully behind the technology and behind its uses nowadays. So what must employers and employees do to bridge the gap in situations like this, to fill in the areas where laws don't really provide the protections that they may possibly should?
Laws definitely don't provide the protections that are necessary in today's technological world. It is something that is being developed, but because of the length of time the legal process involves, both to craft a statute, to pass the statute, to enact the statute, and then for the courts to rule on them, to define the parameters of the protections, it does take a really long time. And the CFAA has gone through quite a bit of flux over the last few years of what it protects, what it doesn't protect. So the advice that I have consistently given over the past years to my employer clients, I represent employers rather than employees, And the advice that I give is to be clear who owns what. And I think that is in both the employer's and the employee's best interest. So employers should have social media use related policies, should have electronic use policies and procedures so that the employer has the right to transmissions that go through its equipment or through its systems so that they can't be taken advantage of by employees. It's also helpful for employees to know where their rights hold steady and where their rights aren't their rights, so to speak. So, for example, if an employee uses, and I've actually had this happen, employee uses the employer's email system to misappropriate highly confidential information, there should be no dispute that that's wrong. But in order to make sure there's no dispute that that's wrong, the employer should have a policy that says, what's mine, the employer is mine. You have rights, employee, of course you've got rights, but those rights stop at this line. And so I strongly recommend to my clients that they clearly articulate what belongs to whom, what belongs to them, what belongs to the employee. Employees have access to free email all over the place. They shouldn't use the employer's system for personal use. Now, you cannot completely prohibit that. I mean, you could. Legally, you could. Practically, it's virtually impossible to do that. So the employer wants to maintain the right to access that information. Even if it turns out that information was private, they have the right to access it. So I do strongly recommend that employers have policies that very clearly describe what their systems and what their equipment can and cannot be used for.
Absolutely, absolutely. I mean, I think the clear message here is that you don't want to have confusion once it comes to a point in time where there might be confusion. Just lay out the communication beforehand. Of course, we don't want to get in trouble with the NLRB nowadays, but at the same time, want to make sure that there is a clear and concise policy there just in place so that there isn't any confusion later.
Certainly, and you bring up a very, very interesting point with the NLRB, and they are all over, both unionized, of course, but non-unionized workers in terms of what their policies can and can't say. And I think it's gotten a little bit extreme, perhaps is the word.
It's crazy to watch nowadays. It'll be interesting to watch going forward to see where these types of cases and those types of cases intersect. So it'll be interesting to watch. Again, that was Martha Zackin of Mintz-Levin and Employment Matters. For more of her insight, be sure to visit employmentmattersblog.com. And for more on this story, visit lxbn.com, search for EdCom, and then click on that Eagle v. EdCom tag for our section devoted to this case. Thanks, Martha.
Thanks, Colin.